This video will provide an overview on the process by which other federal agencies should interact with DOE Laboratories. Another video will be released to discuss details of preparing interagency agreements or MIPRs. The audience for this video is technical and administrative staff from non-DOE agencies and laboratory principal investigators. When the Atomic Energy Commission, DOE's predecessor, was created, Congress gave the agency the ability to allow other federal agencies and private entities the ability to use the laboratories if private facilities were inadequate for the requirement. This requirement still exists today. Some agencies, like DHS and NASA, even have DOE Laboratories specifically mentioned in their appropriation or act establishing the agency, like the Homeland Security Act. You should be familiar with any language that specifically relates to working for DOE within your own agency's authorities, and to provide those special instructions to DOE when funding work, if requested by DOE. However, most agencies work under the authority of the Economy Act, and DOE is under no obligation to do work for your agency. Now that you know it is possible to fund work at DOE Laboratories, how does it happen? There are 3 entities involved in any transaction, and each has their own rules and regulations they must follow. The laboratories are almost all operated by contractors, and their contract gives them instructions. Clause 970.5217-1 is the most relevant for performing work for other agencies. The clause also requires a contractor to have DOE-approved policies and procedures in place, so the exact process may differ slightly from lab to lab. DOE is subject to DOE Order 481.1c, titled Strategic Partnership Projects. This order provides specific instructions to DOE on when special reviews and approvals are needed for different types of work. FAR 35.017 also provides high-level instructions for performing work at FFRDCs by non-sponsoring agencies that DOE enforces. And lastly, the other federal agency, or OFA, is required to follow FAR 17.5 as well as any agency FAR supplement. A unique requirement for funding work at FFRDCs is found in 17.503e, which requires the funding agency to provide a certification to the FFRDC sponsoring agency that the work will not place the agency or FFRDC in direct competition with the private sector. This is the most important requirement for the OFA and should not be taken lightly. DOE will not ask for supporting documentation unless absolutely necessary, but the OFA should be able to support the certification if ever requested. If a private sector entity ever complains to their congressman that a government laboratory is unfairly taking away their business, there will be, and have been, requests for background from the Hill. This is also a topic that routinely is raised by the IGs for DOE and DoD, as well as the Government Accountability Office. The OFA should perform market research to ensure that only the laboratory has the facilities or mix of skills necessary to perform the work. As mentioned on the previous slide, almost all DOE laboratories are operated by contractors using management and operating contracts, as described in FAR 17.6. The contract prohibits the contractor from performing any work outside of their DOE contract, including work for OFAs or private entities. This means that all work must flow through DOE to be placed onto the contract. DOE does not allow other agencies to place orders on their contracts either. All but one of these contracts are visible online and can be found with a simple Google search. Be warned, they are quite long. What is an M&O contract and how are they different from an R&D contract? The concept is that the contractor will manage and operate the laboratory and DOE will only perform oversight. The result is that day-to-day interactions should be between the program manager and laboratory staff rather than flowing through a DOE point of contact. However, the contractors cannot bind the government and the OFA cannot change the contract unless the DOE specifically allows the change. The DOE does have some inherently governmental responsibilities that cannot be performed by the contractor, such as ensuring the work does not compete with the private sector and that the work will not harm ongoing DOE programs at the site. DOE is also responsible for performance management. If the OFA has a concern with the laboratory system, which could indicate fraud or mismanagement, or if the laboratory's performance was significantly less than expected for reasons within the laboratory's control, the OFA should contact the DOE official that signed the interagency agreement so that DOE may consider that information when evaluating contractor performance. I will now go over the process of having work performed at a DOE laboratory. First, a requirement has to be conceived and defined. The OFA Technical Program Manager will need to establish that a requirement exists. This may happen because they read a publication from a laboratory scientist or listen to a presentation at a conference. The OFA then reaches out to the laboratory's principal investigator, or PI, to establish if there is interest in working with each other. It is possible that the laboratory may not be able to meet the OFA's needs. Most of the time, the PI will be excited to have a new application for their work and a new source of funds, and a relationship will be established. The PI and the OFA must then define what work will be done. This is often a cooperative activity, and there is no harm in the two entities working very closely to prepare the statement of work. The PI can be trusted to prepare a budget and apply appropriate overheads to the work. However, OFAs should not be expected to pay a fee or profit on laboratory work performed unless specifically authorized by the laboratory contract. Once the scope is established, the PI will route the proposal package through their management. It is possible changes will be required and additional input will be needed from the OFA. Laboratory management will then review the proposal package to determine if the work fits within the laboratory's mission and strategic plan. They may also perform technical editing on the statement of work and determine if the work can be completed successfully. The laboratory management then routes the proposal package to a technology transfer or sponsored research office within the laboratory for final review. This office's responsibility is to make sure the work conforms with the laboratory's contract and includes reviews relating to counterintelligence, expert control, and whether or not the work satisfies all of the requirements that DOE has in order to approve the work. This office also logs all work to satisfy DOE reporting requirements. Once the laboratory is comfortable with the technical scope and is confident the work conforms with their contract, DOE is requested to approve the proposal package. The DOE review is primarily looking at two things. The first is whether or not the work places the contractor in direct competition with the private sector. This requirement stems from FAR 35.017 and is fundamental for all work performed at the laboratory. As a government-funded laboratory, the contractors have an unfair competitive advantage with the private sector. This advantage cannot be exercised for the benefit of the contractor. The second concern DOE has is whether or not the work will hurt the DOE. This includes considering whether the work will impact DOE programs at the site or will create a future burden. Some work may require hazardous or radioactive material. Are costs for cleanup and disposal included as direct costs, or is this going to be an overhead which will be spread among all customers? Is the laboratory capable of safely performing the work? Are other federal requirements, such as for human or animal research, being considered and appropriately applied? For classified work, is the facility cleared to the appropriate level, or will the PIs have to travel to perform the work? Some of these determinations require subject matter experts which may not reside on site at the laboratory, and this could delay approval of the work. DOE requires the contractors to provide information supporting the review, but the determination is ultimately made by the DOE. DOE must then make 4 certifications prior to approving the proposal package. They must certify the work is consistent with the mission of the site, will not adversely impact programs assigned to the facility, will not place the laboratory in direct competition with the private sector, and will not create a future burden on DOE resources. DOE then notifies the contractor of the approval. Then, either the DOE or the laboratory will inform the OFA that the work has been approved. If the laboratory is authorized to perform Laboratory-Directed Research and Development, LDRD, the OFA must be notified by this point in the process of the LDRD program. If there is an LDRD program, the OFA must participate. The contractor can explain the LDRD program if the OFA has questions. The OFA should also have received some funding instructions either from DOE or the laboratory describing how to send funding for the work. These instructions include the requirements in FAR 17.502-2, which requires the OFA to provide the Economy Act DNF with the funding if the OFA is citing the Economy Act as the authority to transfer the funds, and to provide the non-competition statement required by FAR 17.503E mentioned earlier, as well as laboratory point of contacts and other site-specific information. As with any contracted work, costs may not be incurred prior to the DOE approving the work and funding being made available. If the funding document is received prior to the DOE's approval of the proposal package, which often happens when the OFA is faster than the laboratory and DOE in getting through their administrative process, the funding will be held by DOE until the proposal package is approved. Once the funding is ready to be accepted, the DOE or the contractor verify that budget authority is available. Budget authority is unique to DOE and that DOE is limited in the amount of work that can be done for OFAs. Congress sets this limit in order to ensure that DOE laboratories primarily serve the DOE missions and do not become factories for other agencies. This can become a very big issue towards the end of the year when sites start getting close to their budget authority ceiling. If you are planning to send a large amount of funding near the end of the fiscal year, with large being dependent on the site's normal amount of work for OFAs, but generally anything over $1 million, you should notify the laboratory as soon as possible so that they can ensure that they have budget authority available to accept the funding. If budget authority is not available, the DOE will not accept the funds. The laboratory also matches the funding to a DOE-approved proposal package and then requests that DOE accept the funds. Again, the contractor cannot bind the government, and DOE must accept the funding. DOE also requires that contracting officers sign interagency agreements. Once the CO signs, they will return the accepted IAA form to the OFA, include another statement on LDRD if applicable, and authorize the contractor to begin work. Note that the contractor may begin work as soon as the DOE CO authorizes the work, which is usually before the laboratory's contract is modified. This arrangement is specifically allowed in DOE's accounting handbook. Even though the contractor may begin as soon as the CO authorizes the work, there is still usually a day or two of lag time before the account is open in the contractor's accounting system. Do not be surprised if the OFA knows before the PI that funding has been accepted. Once work begins, the OFA may manage the program similar to if they were a contracting officer's representative on their own contracted work. Interpretations to the project-specific statement of work may be clarified directly by the OFA. Any changes to the statement of work should be routed through the proposal approval process and include DOE approval. There has been a trend towards more open statements of work in order to minimize the amount of DOE interaction required for changes. DOE generally encourages this, but is very project dependent. Projects that touch on a lot of high-risk areas, such as human subject research or access to classified information, may require more specific statements of work than a project that is conducting basic research on new lubricants. The OFA should work with the laboratory contractor to determine how much leniency can be given for each project. Do not expect DOE to manage the project or to identify programmatic problems that develop during performance. The OFA should give and receive immediate feedback to and from the laboratory. It is common for program managers to require recurring reports on project progress and burn rate so that they may understand what they will receive when the project ends. DOE expects the contractor to manage and operate the work being performed for OFAs. If an issue arises that requires DOE attention, the contractor should notify DOE. If the OFA feels that DOE should be notified of an issue that cannot be resolved by the contractor, such as instances of fraud or violation of law, the OFA should contact the DOE official that signed the interagency agreement. Billing is also unique since a contractor is incurring the costs and the federal agency that submits the invoice and IPAC is not actively involved in managing the work. The contractors are also paid in accordance with their DOE contract, which is similar to how financial assistance recipients are paid. The contractors are allowed to draw down on an open account without the need for DOE to approve payments. The result is that DOE floats the payment to the contractor prior to OFA reimbursement. There has been a trend in interagency payments for the paying agency to document receipt of goods and services prior to paying the performing agency. While this makes sense on a transactional basis, this could result in DOE holding a larger balance than they are able to accommodate. OFA should expect the laboratories to provide appropriate documentation to support payments, but withholding payments to DOE could create larger problems. The takeaway you should have is that payments should be made as quickly as possible after receipt of an invoice and IPAC. The accounting systems at both DOE and the contractors default to reimbursement for OFA work. While advance payments can be accommodated, they almost involve some manual effort to modify the account. OFAs that insist on advance payments may find that there are more accounting errors in their work than OFAs that only require reimbursement. Either party may initiate project closeout. If DOE or the contractor initiate, excess funds will be deobligated from DOE's contract and the OFA will be notified that funding may be removed from their IAA. If the OFA initiates closeout, DOE and the laboratory will normally have to confirm the amount of the deobligation prior to accepting any deobligating modification to the IAA. In either case, the contractor or DOE will provide a list of property to the OFA to be dispositioned. If no disposition instructions are received, the property will become DOE property and will be dispositioned as such. Thank you for watching. If you found this presentation useful, you may also appreciate Part 2, which describes how the IAA form should be completed, as well as describing some common mistakes and tips for avoiding them.